Older criminal records can set citizens back in the workforce or in other areas of life, but there have been a few new developments which may help someone get back on their feet by expunging their record. Sean Stottlemeyer is an attorney at Moody & Associates. He is here to further clarify how the law is changing. Welcome to the program.
Thank you.
Good to have you. So really there are two important developments recently in criminal law, both in Pennsylvania and nationwide. What are they?
Well, one you mentioned is the new expungement law signed by Governor Wolf that'll be going into effect later this year. The second one is a Supreme Court decision by the United States Supreme Court affecting DUI law and the blood testing that comes along with a DUI arrest.
Okay, so let's go just a little more in depth. Like, talk to me about expungement. Like, what is it? What does it mean? Who qualifies for it? How does it work?
Well, in this context, with the new law, expungement means that the record would be sealed. So it's not technically an expungement where your record is eliminated, but it's sealed from public view, so employers, people doing background checks wouldn't be able to see it. Law enforcement and court entities will still be able to pull it for later criminal prosecution, but for right now your record would be sealed. What qualifies is a record that is minimum 10 years old. You have to remain arrest-free, and certain violent crimes are accepted from the statute. Most of what is available to be sealed are misdemeanors of the second and third degree or an ungraded misdemeanor.
Is this something someone has to apply for or bring up and say, I would like to be considered, or is it something that automatically happens?
No, it's not automatic. It's something that you need to apply for and most likely seek legal help so you make sure it's done correctly.
At the beginning of this segment, you mentioned DUI. Is that something that can be included in expungement?
It can be anyway under the ARD statutes.
Okay.
However, with DUI law, it's a little tricky because it also goes on your driving record. And even though DUI may be expunged from your criminal record, it's still probably going to show up on your PennDOT record for a minimum of 10 years.
Very good point, good point. So then let's talk more about DUI. You mentioned there's a Supreme Court decision, and that impacts the law in our state.
Correct. It was entitled Birchfield versus North Dakota, and what the United States Supreme Court ruled was that taking the blood of somebody without a warrant is unconstitutional. It would be against the Fourth Amendment of the United States.
So what does that mean in terms of prosecution or in terms of a suspect?
Well, I think right now it's still being sorted out. It's fairly new, but what we're seeing is a lot of courts or a lot of prosecutors are allowing people to plead down to the lowest DUI statute, which is a general impairment, which severely impacts the penalties. For instance, a third-time DUI offender with the highest rate of blood alcohol content and the highest rate would be looking at a 1 to 5 year sentence, a year in prison, where without the blood alcohol, they're looking at maybe 10 days.
You know, it's interesting because, and I'm sorry, this is just a follow-up question for you, and if you don't want to answer it, that's fine, but if an officer pulls somebody over, suspects DUI, and says, we'd like to give, you know, we have to get your permission, we want to do a blood test, and the person says, no, what?
Well, then it's a no, and they can't take their blood. However, PennDOT will suspend your license for a year for refusing, or at least a year for refusing,
okay.
And that is still allowed under the new law.
Oh, that's really interesting. Thanks for clarifying that for me. Good to have you on the show, Sean.
Thank you.